noted, my name is Mark Rowlinson. I work for the United Steelworkers. It's a pleasure to be here, and I have to say the turnout is remarkable, given that it's a beautiful day out here. We're all kind of underground under awful lights. But I won't take up too much of your time. I want to talk a little bit about how the bill came to be, why it's important, and why I think, at least, and we think that this particular approach to resolving this accountability gap is the best way to go, and then I'll leave it open for questions. I have brought with me about 25 or so copies of the bill, the actual bill, if you're interested afterwards, and I've also got a fairly sort of long and somewhat lawyery, frequently asked questions document about the bill as well. I've got a few copies in Spanish as well. So if you're interested and you want to really get into the nuts and bolts of how the bill would work and what effect it would have, please come up afterwards and get copies. So I've been a practicing labor lawyer in Ontario for about 17 years, and I actually first got interested in this issue in the late 90s when Talisman Energy, a company that I know you probably now know perhaps for its activities in Colombia, but back in the 90s, for those who've been around a little while, Talisman was involved in an extremely controversial oil development in southern Sudan in Africa, which they ultimately pulled out of after a significant campaign mobilized by a bunch of NGOs. They were also sued, ironically enough, in the United States under a statute called the Alien Tort Claims Act, which still exists. Now, that lawsuit in the United States didn't actually succeed, but you had an interesting situation where you had a Calgary-based oil company being sued in the United States for activities that it was engaged in Sudan. And someone who works at the Steelworkers came into my office and said, why is it exactly that you can sue Talisman in the United States, but we're not suing them in Canada? So I then got interested in figuring out whether it would be possible to sue, they were based in Calgary, to sue Talisman in Canada over the activities that it was engaged in South Sudan at the time. And I spoke to a number of law professors and ultimately concluded that it wasn't really possible. It could, you could certainly file a statement of claim, but that ultimately it wouldn't really have any legal merit, and it probably wouldn't go anywhere. And that isn't actually a good way to spend our members' money. So we ultimately didn't pursue it. So fast forward a few years later, and there starts to be a lot of discussion about corporate accountability, particularly for Canadian resource extraction companies. Normally when I talk about Bill C-323, I need to spend the first period of my remarks talking about how terrible Canadian mining companies are and their horrible activities around the world and so on and so forth. And I'm not, I don't need to do that at this forum. So it's obviously taken as a given. But it's become a much bigger public issue over the last, say, 5 to 10 years. And you all, and I'm going to talk about this in a minute, you may all recall that there was this bill called Bill C-300 that I'm sure many people on this room knew about, and I'm sure many of you worked very hard to try and get that passed. And I was, at the time, this is about 2007, a friend of mine who had been working at the International Labor Rights Fund in Washington for several years, and he was just back in Ottawa, and so he'd been working on Alien Tort Claims Act cases in the United States, got to talking and saying, the regulatory approach isn't really necessarily a particularly effective way of actually getting at this problem. And so we started to talk about how would we actually craft a statute, a piece of legislation that would sort of operate in the same way as the Alien Tort Claims Act operates in the United States, but it would actually be purpose-built to do this. And the Alien Tort Claims Act, for those of you who don't know, is actually an odd one-line piece of legislation that came into being in the late 18th century, and it was designed to regulate piracy by the then nascent US Republic. And some very clever lawyers in the 1970s figured out that this bill could this piece of legislation could actually be used to potentially sue in mostly American corporations for their acts outside of the United States. So how do we draft a piece of legislation that would work like the Alien Tort Claims Act, but that would be expressly designed to do that? So we started having conversations with Peter Julian, who's the New Democratic MP from Burnaby, New Westminster. And we ultimately came up with, worked with him and drafted a bill that was then Bill C-492, and then became Bill C-354, and now it's Bill C-323. And it's obviously designed, I think everyone in this room knows and understands, as I said earlier, that there is this enormous accountability gap. That we have Canadian actors, Canadian corporations, Canadian individuals who are committing gross violations of human, environmental, and labor rights around the world. We've heard some examples, and I'm sure you'll be hearing many, many examples around during the course of this conference, and who are not at all being held accountable for those actions. So that's what we need to get at this. And so then the bill, again, was introduced initially 4 or 5 years ago, and it's continued to be a private member's bill that Peter introduces at the beginning of each legislature. It became part of the discussion that was sort of subsumed under Bill C-300, and for those of you who don't recall, Bill C-300 was a bill that would have got at this problem in a different way. It would have created a mechanism by which individuals could have filed complaints about Canadian resource extraction companies to a federal public body that would have had an obligation to investigate those actions. And if they found that that Canadian, say, mining company was in violation of a sort of code of social responsibility, there would then have been the possibility that Canadian government could have withdrawn its support for that particular extractive company. So we all know, as was mentioned, that Canadian pension plan funds are invested in Canadian mining companies. We know that Canadian consular services are devoted around the world to supporting and advancing the interests, not just the interests and the public relations of Canadian mining companies. So those sorts of services would have been withdrawn. Bill C-300 was defeated by a very narrow vote of the legislature in the fall of 2010. It was then a minority legislature. So anyway, back to Bill C-323. The other thing that we observed when we were putting together the legislation, and I think it's important to reflect on, is that it is of course the case that lots of, and as my friend mentioned, lots of well-meaning, excellent lawyers acting on behalf of a variety of organizations have been trying to sue Canadian corporations in Canada for their activities overseas. And you're going to hear from Corey Wanless, for those who are here tomorrow, who's going to be speaking about those. But the reality is the success of those lawsuits has been very mixed at best. And the reality is that it is still the case that no Canadian court has actually held a Canadian corporation accountable or has held them liable for actions taken outside this country as of today. It still has, none of these suits have actually ever got to the point where liability has been found. So that's why we need this bill. So what does the bill do in a nutshell? It essentially amends the Federal Court Act to give the federal court jurisdiction to hear a wide variety of cases involving, again, a fairly long list of human rights violations, and you can see them in the bill if you wish, but I will give you, so it's sort of the basic kind of gross human rights violations that you're probably all familiar with, such as genocide, extrajudicial killing or disappearance, torture, prolonged arbitrary detention, crimes against humanity, systemic discrimination, conscription, forced prostitution, rape, sterilization, or death or serious endangerment of persons. So sort of basic list of kind of very core human rights. The bill also would provide a cause of action for violations of recognized environmental rights for the wanton destruction of environmental and the commission of transboundary pollution. And third, it would create a cause of action for violations of key international labor rights, forced labor, child labor, and freedom of association, and so on and so forth, as defined by the fundamental conventions of the ILO. So the idea going into the bill, and some have criticized the bill, is that we wanted it to create causes of actions for a very wide range of international human and environmental and labor rights. There are some who think that international